The trial of the leader of the proscribed Indigenous People of Biafra, Nnamdi Kanu, resumed on Wednesday, February 16, 2022, at the Federal High Court in Abuja. Mr. Kanu appeared in court wearing his regular Fendi outfit, a clear violation of the order made by Justice Binta Nyako during his hearing in December 2021. Back then, the judge asked that he be allowed to change his outfit before the next appearance in court. Counsel to the IPOB leader Mike Ozekhome complained to the court that the DSS have refused to allow Mr. Kanu a change of clothes. Mr. Ozekhome added that Mr. Kanu's younger brother has been refused access to the DSS facility where he was detained on 3 occasions. He also lamented that since Mr. Kanu was arrested and detained, his eyeglasses were seized by the DSS and have not been returned to him. He requested that his glasses be returned to him so he does not go blind. Justice Nyako, responding to Mr. Ozekhome's complaints, asked the Director of Legal Services of the DSS to provide explanations to the issue. The director said, "My lord, clothes that were brought for the defendants had a lion's head embroidered on them, and the defendants can't wear clothes with a lion's head." He further explained that clothes with lion's head offend the standard operating procedures of the DSS. The judge, however, asked the type of clothes Kanu prefers to wear. Responding, Kanu said, "I want to wear the clothes of my people, Ishiyagu." The court, however, refused his request but asked the DSS to provide Mr. Kanu with his glasses, which his lawyers said were taken away from him. Here is Mr. Ozekhome speaking with newsmen after the hearing.
Which again was seized from him and broken when he was captured in Kenya like a common criminal and forcefully renditioned to Nigeria. So today he has no glasses to use. So the court now has ordered the DSS to ensure that he gets his glasses. Then on the issue of clothes, if I'm here, Ejiofor, and the younger brother of Nnamdi Kanu and others have taken clothes to him 3 times, and they will refuse to take the clothes. It's today we are hearing for the first time that the reason is that one of the clothes had the motif of a lion. That is a lion. We all know this is Ishagu, this Igbo clothes. I have some of them. Some have elephant, lion, tiger, giraffe. Some have cock. Some have antelope. So it wasn't meant to intimidate the court or to make any point. So we are hearing today that they won't want that kind of clothes. And the court has made it clear that it is better, instead of wearing a cloth that has that motif, he should wear plain clothes. The design of which is still left to him, it should be plain. It could be black, red, white, green, yellow, sky blue. It doesn't matter. And we also agree to that effect. That from now onwards, the cloth we give to him will be plain clothes. We didn't know that was the headache of the DSS. According to what the director said, he said it goes against their procedure.
Also, the prosecution counsel, Shuaibu Labaran, informed the court that the defense counsel had filed and served him with 2 applications, which he had responded to accordingly. Labaran said the first application is seeking an order quashing the 15-count amended charge leveled against Mr. Kanu, and the other one seeking his bail. Mr. Ozekhome, however, said he has an application that basically seeks the quashing, striking out, and dismissal of the 15-count amended charge against Mr. Kanu. He argued it was incompetent and denied the court of jurisdiction to entertain the 15-count amended charge. Here is Mr. Ozekhome again.
All the 15 counts in the charge are bad, and bad. Like I described it before the court, they are as dead as dodo. All that the court requires is to give them a decent burial. Because there is nothing whatsoever in the counts at all. You are accusing Nnamdi Kanu of making some broadcast. You didn't say where this broadcast was made. Was it made in the spirit world? Was it made in the air? Was it made under the ground? You didn't state.
He goes to say the federal government is accusing Mr. Kanu of making some broadcasts which were in furtherance of some treasonable acts, whereas no treasonable charges have been filed.
For you to charge a person with furthering treason, you must have to charge the person with treason. Nnamdi Kanu is not charged with treason here. We call it the predicate offense. It is from this predicate offense that the acts of furthering will emanate. So they are building castles on empty air. There's nothing to support it. You are saying that the broadcast he made led to protests, violent protests in the east and in Lagos, affecting Lagos transportation system. Does this court have jurisdiction territorially over Lagos and matters that happen near Uli, near Ihiala in Anambra State? No. Does this court have jurisdiction over matters if there was an offense committed, for example, say in UK? Does this court have jurisdiction over matters that happen in UK? Answer, no. Because this court cannot exercise jurisdiction on matters within a sovereign land, another country that has sovereignty under international law.
Mr. Ozekhome also cleared the air that Nnamdi Kanu has never denied being a member of IPOB.
Contrary to what the prosecution said last time, Nnamdi Kanu has never denied being a member of IPOB. He says, I am not a member of proscribed IPOB. I want all of you to know the difference. And when IPOB was proscribed through the court process, Nnamdi Kanu challenged it. The matter is at the Court of Appeal currently. Nobody knows the judgment of the Court of Appeal. If the Court of Appeal finally says that this proscription was wrong, as we are contending, let's say by that time you had already tried Nnamdi and jailed him, how will you bring him back? So you are trying him under a law that is inchoate, that is being challenged, whose efficacy and longevity is being tested and has not been finished. So we call it lite pendes, or the doctrine of sub judice. So you cannot. So Nnamdi Kanu, in his extrajudicial statement, said he founded IPOB in 2012 in London, and that is the head. He has never denied being the founder, head, and member of IPOB, but he denies being a member of proscribed IPOB. This point must be made clear.
The defense counsel added that the application, with 34 grounds and supported by a 36-paragraph affidavit, could not be denied by the court.
The entire affidavit and a better affidavit, including points of law, they could never deny any of them. They just did what you call general denial by saying the prosecution denies the affirmance in your affidavit. What are you saying to it? What did they say to the fact that Nnamdi Kanu was extrajudicially rendered and renditioned to Nigeria? They don't have a word. What do they say to the fact that this case is on appeal and you cannot charge a person on a law that is still inchoate? They have nothing to say. What do they say when we said that this court has no jurisdiction? Because you have not said that the law was breached here. You are saying it was breached in another country and it had ricocheting effects here. Where is the predicate offense, which is terrorism, which you did not charge him for? They have nothing to say. So everything they have here is hollow, and hollow.
Mr. Ozekhome, however, requested that the case be struck out.
And that is why we are telling the court to strike out the 15-count charge, discharge and acquit Nnamdi Kanu, let him breathe the fresh air of Nigeria, and let him go home a free man.
This matter has been adjourned to April 8, 2022 to rule on Mr. Kanu's applications to quash the charge.